Hello friends, we would like to discuss in brief about trust and wills. But there is a question that why these days most of the families are preferring the trust over the wills. What is the difference? Do we have any option or is it a mandatory that somebody should have a trust or a will? So in fact, whether it is a trust or a will, this is rotated towards the property transfer. Will particularly is the transfer of the property after a particular person dies. So normally we call it the intestate if there is no will is there. So estate has to be with a will, otherwise it becomes an intestate. So in case of a intestate, who are the claimants? In case of a intestate where there is no will, any member, blood relations including family members, can challenge and take the will, whereas take the property. Whereas if will is given specifically to a particular person, he may be a family member, he may not be a family member. So after his death, the property goes to that particular person or persons. That doesn't mean that it is totally free of any legal complications. Legal heir certificates, all those things will be there. There will be mainly high net worth individuals, normally we call as the HNIs and NRIs, whose properties are more, they are preferring the trust over the wills. For simple reason, there are less legal complications as compared to the wills. See, normally smooth transfer for the wealth, generally will is planned, so that after the person's death there cannot be any clashes that it is my property or his property. Usually the wills are the most common methods. The wills can be registered and without registration also the wills can be there. So even an unregistered will is valid if there are no legal complications. A smooth sailing, normally like a father to son or son daughter. These days actually the Hindu Succession Act 1956 started the properties to the only the sons. In 2005 amendment, now the property is to be shared equally among the daughters and sons. So there are some legal issues are there, and this is with the Hindu Succession Act. And with respect to the other, like a Muslim law, there are certain differences are there, and other Succession Act 1925, there are certain differences are there. So now basically our focus is what is the trust and what is the will, which is better, and why the people are trending towards the trust rather than the wills. See, one of the reason is the will is a legal declaration of the person, and it is valid only after person's death. It can be changed any number of times, but it comes into the effect only after the person's death. And in many cases, the will is not a smooth transition process. There are certain legal implications or legal orders to be there. Normally we call as a probating. Probating means issue of the legal rules and regulations. In some states or some of the Indian states, they made it mandatory that even if it is a will, particularly the court order is required based on the will. If there are no complications, no litigations, the will is smooth. Otherwise, it will go the course of action with all the legal procedures. And any will can be challenged in the court, because the will is valid only after person's death. So person cannot come back and say that I have written like this. So after his death, whatever the things are there, it can be challenged whether the signature is same or the will is given under the duress to somebody under the pressure, or the person who has written the will was not insane. There are so many legal issues will be there in case of a will. But with respect to the trust, no such complications will be there. That is the reason some of the, at least rich people, are turning towards the trust. Now let us know the details. For the will, it is revocable during the lifetime, and it is one of the very simplest and inexpensive to create. There is not much, even without registration, simply bond paper, you can write the will and it is valid. So you can save the court fee or registration fee also in case of the wills. But only thing is there are no tax benefits of the will during the lifetime. Whatever the property, it may be the money or it may be the assets, whatever the type. And always the will is subjected to the probate, that is the court supervision. And after the probate, it becomes a public document. So, for example, Ram Mandir asset is there. After the court declaration, all the Ram Mandir documents are made public. Anybody can see, and if somebody really feels any particular issues with the will, they can certainly challenge even after the verdict also. So those are some of the things. Will becomes a public after the probate, after the court order. Now coming back to the trust. Trust is nothing but a legal arrangement between a settlor and the trustees. Settlor is the one, a person who have the assets and who wanted to give it to some beneficiaries through trustees. Trustee are the managers. Trustees are not the owners, and they are not the representative of the owner also. They are only the managers of the owners, and there will be clear-cut terms, conditions, who are the beneficiaries. All those things will be written in the trust. And trust should be registered. It is governed by the Indian Trust Act 1882. It's going to be revised again like any other Indian act in the British time. So trust can be created during the lifetime. That is called, we call as a living trust, or through a will also, testimony trust. Here there is a slight difference between the will and a testimony trust. It is not a normal will. It is a trust, but the trust becomes effective only after person's death. That is what we call as a testamentary trust. In case of a will, it is only after the lifetime, but in case of the trust, it can be both lifetime and after the death also. And mainly in the trust, there is rules, regulations, who will be managing, what are the protections, all those details are mentioned in the trust. Some of the important features of the trust is that it operates immediately. The moment I created a trust, immediately start operating. So I have some assets for a particular benefit, and I appoint minimum two persons to take care of this, to manage the things, and they will take care during my lifetime. And certainly, if there is any changes are required, I can certainly make do, but based on certain rules and regulations. So, trust can be flexible also. Like will is also flexible. You can change during the lifetime. So trust is also flexible. It can be revocable. It can be irrevocable. Both advantages will be there. And all the trusts are managed by the trustees as per the instructions. And the trustees, whatever the assets and what is the money transactions, they can have a tax planning benefits also. And a trust is not a public document. Unlike the will, after the probate, after the court order, it becomes a public, but trust is always a private document. Some of the differences is that governing law for the will is the Indian Succession Act 1925, Hindu Succession Act 1956, which is amended in 2005 and 2019, and based on the other religions like a Muslim law. Whereas in the case of a trust, it is a Private Trust 1882 Act. And applicability, will is applicable to all, like Hindus, Christians, Parsis, and Muslims, they have a separate rule. With respect to the legal trust, any individual or any Hindu undivided family or any other institute, they can create a trust. Whereas in case of a will, it is by person, by the family, they can, based on their property, they can do it. And with respect to the probate means something legally bound. So the trust requires the probate, and particularly in some of the states, it made mandatory. Although the will without registration property can be transferred, but some states says that court order is to be required. And with respect to the trust, the probate is not required because it is totally private, so there is no issue. And with respect to the will, registration is not mandatory, except in some cases, but in case of a trust, registration is mandatory, particularly if it is an immovable property that will be transferred. And with respect to the will, there is no tax impact until the death. There is no need to pay any taxes even if you have so much money also. so long it is not used. With respect to the trust, whatever the money is there, you have both income tax liabilities, at the same time income tax benefits also. And with respect to the court supervision, will is based on the probate court. The court will supervise, and with respect to the trust, it is the managee. The minimum court supervision will be there unless there is some litigation. And these are some of the differences. These days, the question is why families are preferring the trust means mainly these families means mostly the rich families like high net worth families. They are preferring because they don't want any, by giving the will, they don't want any court delays. So the trust automatically during the lifetime they can enjoy, they can change it, and after the death also, whatever the terms and conditions, it will take care. Whereas if it is a will, there are probate or a legal delays will be there. And with respect to the trust, it is a private and confidential, unlike wills. Wills is a public. Once it becomes a court order, it becomes a this one. And with respect to the trust, a minimum reduced litigation. There is hardly, unless there is some issues are there, like I have created a trust based on somebody's property, then they can challenge. Otherwise, if it is my trust, there is no issue. Whereas in case of will, if it is my own property also, once I have given to somebody, and there may be so many claimants will be there after the death. So these are things. And continuity in management is one of the important things with the trust. And tax and wealth planning can be, you can plan very well how the trust benefits or beneficiaries are there, how the monies are maintaining. And with respect to the family cycle, it helps in a seamless transfer. Particularly, you see, like there are several trusts are there, like Birla Trust, Tata Trust, and all that. All the trusts are seamlessly transferred to the next generation or next management. So there are not many issues will be there. And like I said, the trust is for the high net worth individual families, and NRIs normally consider the high income groups, where the certain legal restrictions will be there for the transfer of the properties. So, and cross-border assets also can be there. Like some NRIs has the properties in some other countries, whereas the beneficiaries are in India. Certainly, trust can be more beneficial and less litigant as compared to the wills. And these are the recent trends, and the people prefer the trust only because they are the private and there are less litigations with respect to the court. And living trust is more smoother. For example, I wanted to retire. After giving a trust, I manage it. I wanted to retire, I can transfer this one. Whereas in case of a will, unless I die, it cannot be transferred. And with respect to the trust, lawyers and wealth managers, they can easily manage the things because the rules and regulations are very clear. And the family feuds, family complaints can be reduced in the. That is the reason people are preferring this one. However, there are certain challenges like a trust registration is a costly affair, and there is a professional fee, and normally you need to have the one legal advisory for the creating the trust and all those things. Whereas in will, it is not that much important. And will has virtually no, unless you wanted to register it, there is no just a bond paper you have to write and you can sign. That is the only advantage with a will. But in trust, you have to spend some money. And trust, they should be always reliable and competent. Not everybody can do it. That's why at the time of registration, there are so many conditions that you need to fulfill. That is exactly you need to maintain. And with this brief information, I thought what is the difference between the trust and will, and why the families are trending towards the trust. I think it is very clear to the audience. And if you have any questions, you can use my email, and which is there in the description box, and I'll revert back to you. Thank you very much. The final thought is that why wills express your vision. Trust ensures the execution without any delay. This is the main and important thing. Thanks again.